One of the impacts of the internet is that many of us who didn't expect to be are suddenly publishers and citizen journalists. Doctors, patients, activists, unionists, NGOs publish things all the time. That means that when we write or think about controversial issues, we can face legal liability. So I'm going to talk very broadly about how to handle the risk of talking out about controversial issues. And I'm going to do so to give some context to the dispute that's happening here, although I don't pretend to know anything about it at all, apart from what I read in the newspaper. But the first thing I read in the newspaper was what NHS England's lawyers, Beechcross, wrote in August last year. And it was this: NHS England does not accept that the result of this procurement puts patient safety at risk or compromises the provision of cancer care and research in the health system. We are bound to put you on notice that any statement in those or similar terms would be defamatory if repeated to any third party. Now that's an incredibly broad, sweeping claim. It's also legally wrong. Now, NHS in their letter, was it today it arrived? Claimed to have clarified that all they were doing was trying to be helpful. They were alerting doctors and the trust that if they repeated those allegations, they might be at risk from other unspecified third parties for whom they don't act. That is completely disingenuous. Lawyers are used to using language precisely when they're talking about the law. It's an intimidating statement. So the purpose of what I'm going to say is a gallop through libel law and other laws that restrict speech, and give you an overview of how to be robustly but safely critical in this area. So first of all, what is defamatory? Any statement made to a third party, so it doesn't matter if you say it to the person themselves, about a person or an organisation which causes serious harm to reputation. Okay? In the case of a company that trades for profit, it has to be serious financial harm is caused. Now that's new, that's from the Defamation Act 2013. The threshold's been raised. So it's intended to be serious harm. It's intended to be a proper threshold, not trivial or criticism. So the first step when you're reviewing a statement for libel is to say what is the defamatory meaning. Now often a statement can mean different things to different people, but the judicial fiction is that there's only one meaning, and it's a notional reasonable reader's meaning. So the first thing is the judge decides what is the reasonable meaning. So the statements that we're talking about, in this case, the meaning is fairly clear, that a body has put patient safety at risk and compromised cancer care. That's what's being said about NHS England. Now that is potentially defamatory. It has a defamatory meaning. But, and this is the very big but, the next question is who can sue for libel? NHS England is, and I had to look this up, an executive non-departmental public body of the Department of Health and Social Care. In a case in 1993, Derbyshire, heard by the House of Lords, Derbyshire County Council tried to sue the Times in relation to a story about its investment activities. The House of Lords decided that an organ of government or local government could not bring an action for defamation because of the chilling effect on free speech. This is an iconic case. Lawyers know about this case. Lord Keith said, and I'm going to read it because it's quite a nice little extract from the judgment, it would be a serious interference with the free expression of opinion hitherto enjoyed if the wealth of the state derived from the state's subjects could be used to launch against those subjects actions for defamation because they have, falsely and unfairly it may be, criticised or condemned the management of the country. So that's quite a sort of ringing statement by the House of Lords, that where you're criticising a public body carrying out public functions using public money, there is usually for free speech reasons, no possibility of a claim in libel. There are some limits to this case. Since Derbyshire, a university has been treated as being able to sue for libel, and individuals who can say they were criticised themselves can still sue for libel. So the limits are that the body can't sue for libel. So if the doctors had said or implied Simon Stevens has deliberately compromised patient safety, or that an expert clinician who evaluated the bid had been reckless about patient safety, those all had, people could identify who you were talking about even if you didn't name them, those people could still sue for libel. But that's not this case. In this case, the criticisms are of the public body itself. The public body has no business threatening a libel action. So the first tip for people who are talking in this area is criticise NHSE, not the individuals. Make sure what you're saying can't be understood as a criticism of individuals working in NHS England. This is also another aspect of creeping privatisation. If a private body is carrying out public functions, at the moment they can still sue for libel. It's not been tested yet, so that's another possible problem of privatisation in the health service. So that's where we are before we even get to a libel case. They're even entitled to sue. So even if in principle they have the right to sue, there are a number of hurdles. First hurdle is has serious harm to reputation been caused. Irritation, if someone's offended or furious or upset, distressed, that's not enough. It has to be serious harm. And if you're going to say it's serious harm, you have to prove it. Even if serious harm can be demonstrated, you get to the next hurdle. Can the claimant beat the defences? If the defences are strong enough, you can knock out a claim at a very early stage. And what happens quite often is somebody writes a threatening letter, instruct lawyers write back saying, this is ridiculous, here's the defences, if you issue, we'll strike it out immediately and claim costs from your clients, don't you dare. And very often they go away. And that is often the way to handle an intimidating threat. And it does mean that you sometimes have to go to lawyers to do that, but it's one letter, and one letter written at the right time by the right person can save you an enormous amount of trouble later on. I'm not saying that because it's my job, it does happen. So these are the cases, these are the defences that you might be able to deploy. First one is truth. You might think, well, it's fine because it's true. In fact, truth is a defence that's very rarely used in libel cases. It's difficult. If you have to yourself prove it's true. And we can trust our learned judges mostly to get the law right, but we certainly wouldn't trust them to be able to decide whether you're right or InHealth is right about the quality of the scanner. And it would require a lot of expert evidence to get to that point. If you can knock a case out on a technical legal point earlier, you're in a much stronger position. So the defences that are relied on all the time are honest opinion, public interest or privilege. So what are those? Public interest defence is quite a new defence again from the 2013 Defamation Act. It used to be a common law defence for responsible journalists, but in our changing world it now applies to all sorts of public interest statements. All you have to show is that the matter generally is a matter of public interest. In this case it certainly is, a matter of very high public interest. And the author or publisher has to show they had a reasonable belief that publication was in the public interest. Now, reasonable belief has two sides to it. It's a subjective part, do you actually believe it yourself? And an objective part, is your belief reasonable in the circumstances? What would I do to make sure that my belief that the criticisms I was making of NHS England were reasonable? Well, I'd talk to the consultants, I'd keep a note of what I'd said to them. I'd make sure that I'd asked around. I might also need to speak to NHS England and get their side of it. I'd do a bit of fair-minded digging before publishing. And then I would be able to show that my belief that this should be out there, people should know about it, was a reasonable belief. So the second and third tips together are public interest and honest opinion. So opinion has to be a statement of opinion. So obviously, something which is actually a statement of opinion, that's more difficult than you might think. Boris Johnson is crazy is obviously a statement of opinion. Everyone knows who he is, what he says, and that's just my view about him. And people might say, well, I don't agree. But if I was to talk about an unknown person and say that they're mentally ill, then that's a statement of fact about them. But they're quite close. So anti-Semitism is another one that came up in a recent case, where someone was called a notorious anti-Semite, and that was held to be a statement of opinion, not fact. So it has to be a statement of opinion. The best way to make sure it's a statement of opinion is to say, I think, in my view. Then it's like, that makes it easy for everybody. You have to indicate in general terms the basis of the opinion. So if you say, this scanner is less effective than this scanner, I think it's an absolute disgrace and a terrible outcome for patients that the NHS England is choosing that one over another. Then you're expressing the basis of your opinion, that's why you have that opinion, and then you're saying what your opinion is. If it's an opinion, you can go quite far. You can be offensive, you can be really, really rude about things, it just has to be opinion. So maybe that's tip 3. Express something as your opinion. It's much better than saying allegedly, as they always used to say in Have I Got News For You. The next part of the opinion defence is that an honest person could have held that opinion on the basis of any true or privileged statement. So it has to be, you can't get away with it if you have a completely mad opinion that nobody could honestly hold. That's not going to be a problem. And it has to be on the basis of not a true statement or a privileged statement. So, Philip Green was named in Parliament as the man who obtained the injunction to prevent allegations of sexual abuse becoming public. Because it was in Parliament, it was a privileged statement. That having come out in Parliament as a privileged statement, anyone can then say, I think he's a vile, disgusting human being who ought to be locked up. I think he's just trying to muzzle the press. People could then comment on that privileged statement, whether it was true or false. It doesn't have to be true, it's privileged. Now, I'll mention very briefly, because it may be relevant here, the statutory privilege. You need to look this up. I need to look this up. There are lists and lists of court proceedings, Parliament, notices issued for the benefit of the public by shareholders. And it's always worth checking if you're in if what you're saying is privileged. The other one is peer-reviewed statements in a scientific or academic journal are also privileged. Can't be sued on, unless they can show malice. So that is a kind of gallop through libel law and libel defences. There are some other areas to watch out for. One of those is breach of confidence. Very often, organisations will claim that what they're talking about is confidential or under legal review, which is, in my legal analysis, nonsense, and that nobody can talk about it. Now, first of all, the information has to be actually confidential. Even if it is confidential, there is a public interest defence to publishing confidential information. Now, it varies slightly. If it's information which you've already agreed to keep confidential in a non-disclosure agreement, for example, then it has to be a very high order of public interest to defeat the obligations you yourself have accepted. But if it's confidential just because you came across it during the course of your work, then the public interest is accordingly slightly lower, so the scale adjusts. So the press quoted Adrian saying that the Cancer Network and Commissioning Group were told they couldn't discuss the contract or any concerns because it was under legal review. Now, that simply doesn't make any sense. You know, it may be that there are times when it's appropriate to think about writing letters before claim to NHS England, because despite what NHS England said in their letter, you can sue a public body. I mean, there are various privileges or something. A public body can't sue, but you can sue a public body. So that's just you may think it's going a bit far to just turn the tables, but it's there.